Oh. Hey. Hey. How are you guys doing? Hello, Northwest Iowa, and everybody from east of the Rockies. Your lone wolf Oozle is online. It is Saturday, and this is the weekend case review. Welcome, everybody. Ladies and gentlemen, it's Saturday. I'm Lone Wolf Oozle. This is the weekend case review, and we've got a full show for you today, about 2.5 hours worth. And if you look down at the little picture down low, you'll see we got a whole bunch of judges. Judge Iorochi, Judge Khan, Judge Webster. Judges, I don't even remember their name. But, you know, Judge Ricky and Judge Mogan. It's Marin. It's Judge Marin. I do know his name. What am I saying? He's from Texas. It's Van Zant, Texas, ladies and gentlemen. But we are starting off in Ohio. Ohio, ladies and gentlemen, where things are going to get spicy. We're going from the first day of the week to Thursday because we all just saw Friday. Friday was crazy. But right now, well, you know what's happening. We're getting started.
Court is on the record in City of Contempt versus Brandon Lee Butts, case number 25 TRD 408. In this case, Mr. Butts pled not guilty to one count of driving under FRA suspension, a fourth-degree misdemeanor, and guilty to one count of a turn signal violation on May 27, 2025. We conducted a first pretrial conference on June 9th, 2025, and today we're set for a second pretrial and sentence in that case. Court is also taking up, there are two other cases. State of Ohio and City of Contempt versus Brandon Butts, case numbers 24 TRD 773 and 22 TRD 540. At a review hearing on June 9th, 2025, in these cases, Mr. Butts appeared with his attorney, as well as Law Director John Lewis, and court made a finding that pursuant to this court's February 21st, 2025 order, Mr. Butts was ordered to pay $50 per month, or $50 on February 20th, 2025, and $75 per month commencing March 13th, 2025, and thereafter no later than the 13th day of each month thereafter on the captioned cases until all fines and costs are paid in full. He was also ordered to successfully complete 50 hours of community work service no later than May 15th, 2025, in case number 24 TRD 773. Court made a finding on June 9th that he only paid $50 on February 20th and that no other payments had been made. Court further found that the defendant had not presented the court proof that he had performed any community work services ordered by the court. I appointed the public defender's office to represent him. Set the hearing today, July 7th, 2025 at 10:30 a.m. pursuant to section 2947.14c of the revised code on the defendant's failure to pay fines, and also a contempt hearing for today, pursuant to section 2705.02, for Mr. Butts to show cause as to why he should not be held in contempt of court for failing to perform community work service in compliance with this court's February 21st order. Mr. Butts is present today. He is accompanied by his attorney, Philip Heasley, also present as Law Director John Lewis. Okay, we're going to address the pending case first, that being the 25 TRD 408 case. Mr. Lewis, the court is in receipt of a pretrial report.
Yes, Your Honor, thank you. The offer that's been extended to Mr. Butts on that case would be to plead to the driving under suspension charge, and the parties would then argue sentence. Based on my research this morning, Mr. Butts is not currently valid. So that's the offer on the driving under suspension. Thank you.
Thank you. Mr. Heasley.
Thank you, Your Honor. Mr. Butts is making payments and doing what he can to obtain a license.
Yes.
These are, of course, different proceedings, and
I'm just addressing the first case first. I'm addressing the pending case right now. That's what I'm addressing. I'll address the other cases here shortly. But right now I'm addressing the pending case where he has pled not guilty to driving under FRA suspension in 25 TRD 408.
we would request, Your Honor, a further pretrial to allow Mr. Butts to make further progress towards obtaining a valid license in this matter. Thank you.
Well, my research shows that there's no way he can become valid until December 27th of 2025. So I'm not scheduling this beyond that date. I'm not going to do that. This case is going to be held in a short track. I will grant your request for a final pretrial conference that will take place in roughly 30 days from today. Okay, now we're going to address the other pending cases. Mr. Keesley, do you have any evidence to offer on behalf of your client today?
Just as he's indicated, Your Honor, he's indicated that he has not performed the community service, which I believe is the basis for the contempt citation. He does. He indicates that he does have money to pay towards fines and costs, Your Honor. He told me that he has possible employment at the Love's truck stop. Is that correct? And the other case, Your Honor, that this is a first pretrial on when we would request to be held in conjunction with the one that has been granted within a short date, a further pretrial, and hopefully either resolve these or conclusively set it for a trial. Your Honor, he's aware of the community service obligation. He Are you planning on doing that?
Yes.
How?
That's the
Well, the court will
yeah.
give you an opportunity to speak for yourself. Thank you, Your Honor.
We're going to conduct a contempt proceeding, Mr. Easley, today. Does your client have any reasons that he would like to show cause as to why he should not be held in contempt of court for failing to perform the community work service in compliance with this court's February 21st, 2025 order?
I would have him address the court, Your Honor, in the form of testimonies to say that as to address that issue. Thank you.
You would like to call your client as a witness?
Yes, sir. Would he be up there or would he be?
No, I'll have him stay seated there.
Okay.
Mr.
Yes,
Butts,
sir. Thank you.
raise your right hand. You solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Okay. Mr. Heasley, you may proceed.
Thank you. Mr. Butts, this is regarding the contempt action that was filed against you regarding failure to abide by court orders. You understand that, sir?
Yes.
Okay. Could you, in your own words, explain why you have not done community work service as of now?
Community service, we had a double family emergency going on, and I know that ain't no excuse for like getting it proceeding or getting it done.
What were those emergencies? In your own words.
Well, recently my grandmother passed away, and then my problem with transportation getting this place to place, it's been a problem because I figured out that the bicycle thing was just copying wrong with that for his suspension. And then just trying to find employment, trying to get around right now is pretty hard for me.
Are you willing to complete the community service?
Yes.
How long do you think that you would be able to complete it?
I mean, I can start getting hours in within this week. I can go to the AVL or December.
Are you currently employed at the moment, Mr. Butts? You do realize the court has the authority to incarcerate you over this.
Yes.
You do realize that.
Yeah.
Are there any other places where you could do community work service?
They give me a list of places I wasn't too sure.
You have a list?
Yeah.
Okay. You mentioned your grandmother's death and transportation issues.
Yeah.
Were there any other reasons why you could not get this done?
No.
Okay. Are you in good physical health, Mr. Bunce?
Yes.
Okay. Nothing further, Mr. Bunce, Your Honor. Thank you.
You have any questions, Mr. Lewis?
I don't have any questions, Your Honor. Thank you.
I want to know, I ordered you to do this by January 31st. I ordered it in November, on November 12th. So I gave you 60 plus days, more like 75 days to do community work service. So here we are, July 7th, almost 8 months since my original order for you to do community work service, and you produced no evidence of any community work service. Is that true, Mr. Butts?
Yes.
And your reasons is that your grandmother passed away and you have no transportation. Those are your only reasons.
Well, yes, the transportation was the main thing because due with like everything that I thought was legal enough to drive on the roads under like there's nothing in Ohio State or any shows the bicycle stuff. So that's why I've been trying to get back and forth on bicycle until I got pulled over on that, and that caused me another problem. So basically, since that bicycle incident, there's been problems getting anywhere. I haven't had really any transportation way to get around.
So did you ever think about reaching out to the court to at least provide the court any kind of notice that you cannot perform community work service before the court had to conduct a hearing on this?
No, because I can honestly tell you no, because every time I ever try to reach out for some type of sort of help, I usually get them wrong end of the stick. And like,
Stop playing victim to me, Mr.
I'm not
Butts.
playing.
Yeah, you are.
No,
I always get the wrong end of the stick. I don't, when people sit in that chair, the last thing I want to hear is them playing victim.
I'm not trying to play victim.
Yes, you are.
Now,
Now, why don't you have a license?
because I owe so much on my.
Right. Whose fault is that?
Well, I thought undercut.
Whose fault is that?
That's my fault, but I'm
Okay, right. Take him into custody. You're in contempt of court. You're in contempt of court for not doing your community work service when you're supposed to do it. And you know what? I'm going to have you drug tested. You are subject to drug testing. We'll reschedule this hearing next week.
Stop. What?
Stop it. Mr. Butts, don't resist, or I'll push the buzzer and the police department will be coming running up here.
What the fuck?
Let's call Kevin Bello. Good morning, Mr. Bello. Give me a moment to pull up your file. I have two separate cases. We'll call case number 2616 first. All right, you were in front of Judge Hill back on June 10th, and we reset the case for today's dates to allow you the opportunity to see discovery, the police reports from the prosecutor's office on that case. I don't know whether you've received that yet. Have you received the police reports from them, the discovery?
I got the police reports. They're all false.
Okay, so
I couldn't see the video from the police camera.
okay.
I don't know why. I mean,
Sometimes I think I've seen that they send a link.
to this day, I can't get that.
You weren't able to
right.
So it might be worthwhile having a follow-up conversation with them, because what you're saying to me is you don't agree with the facts that are in the police report, number one, and you couldn't review the video that you were hoping to be able to see, right?
Yeah.
So,
but I also just want to, try and get this done.
and that's,
I got things to do. This is taking a lot of my time.
I understand, and that's part of the process. Obviously, when you get charged with a criminal offense, it can take some effort to get it resolved. All I can do at this stage is give you the options that you have. You haven't entered a plea to any charge. If you decide to plead guilty to the charge, then we would go forward with a guilty plea. But if you'd like to have a conversation with the prosecutor and have a follow-up conversation with them, you could do that this morning.
I honestly don't know what to do anymore because this is just going to take up more time. waiting for a prosecutor. I'm not guilty. I'm innocent. I'm innocent, innocent. You know, I don't know how else to say it to you guys. You know, but I don't know what else to tell you, honestly, dude. I've been dealing with you guys for a lot, you know, for unreasonable reasons, for false accusations. I just want to be done, man. Get the fuck out of here. Be done with you guys in my life. Continue with my life and my family, my kids. You guys have just gotten accusations, false accusations from people that don't even fucking know me. You guys take the charges, hammer me with them, and try and get money and 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 money off me every fucking time. I'm done with it. I'm fucking sick and tired of you guys. The police charged me with shit that I should not even got. I got my ass fucking handed to. I'm not gonna lie, dude. I got my fucking company, my kids. I stood like this and let these people beat the shit out of me. I do not deserve anything of what you guys are giving me. I do not deserve any of these fucking charges. I got my fucking ass beat by 5 guys, and that's brawling? How is that brawling? They jumped me. That's all there is to it. That's the truth right there. I don't know what the fuck you guys got to keep sorry for my language, what you guys got to keep investigating for 3-4 fucking months.
So let me try to, and I want you to take a couple deep breaths if you don't.
Like, this is taking my time, man.
I understand.
Last time I came here, I lost work. I couldn't pay my rent because of that shit.
So can you pause for a moment so I can respond to what you said?
Well, at least you gave me time to talk, so thank you. You guys never give us fucking time to talk.
I want you to be able to be heard. And
I want this to be done. I didn't do nothing.
I understand what you're saying. I just want you to understand the judicial process.
I know the traditional process.
Well,
and it's all bullshit.
It sounds like you don't understand the roles. Let me explain.
I do understand.
I don't have any.
I've been in your system since I was 13 years fucking old, dude.
All right.
You guys do not let me go.
Can I speak? I just want.
Go ahead.
We can both speak, but you got to let me talk too. Okay. I don't have any authority over the executive branch, which is the prosecutors and the police department. They may have decided that they think that there's a charge that they can prove against you. My job is to make sure that you have your fair rights addressed here in court. The only way we can do that in a fair way is for me to tell you about the charge that's been presented to you.
She does, right?
What's that?
She does, right?
She's the prosecutor.
Yeah, she have that what you're saying. Because I spoke to her last time.
She does have the ability to make decisions on how the prosecutor's office wants to proceed with the case. That's her.
I don't want to take time and talk to her on the outside.
You do
this now?
You want to talk? Well, there are other people in front of you, so she may not be able to meet with you this moment. But yes, you can have a conversation.
She has an offer from me. You said she has a case that she could file against me.
She doesn't have there's not an offer in the file.
So what's going to happen? I'm just going to reschedule this, hear it again, and go through the thing.
We don't need to reschedule it yet. You're here today. If you'd like to have a conversation with Ms. Keller when it's your turn to speak with her, you'll have that opportunity. So there's other people who are waiting to see a prosecutor. You'll get a chance when it's your turn. Understand that she represents the government's interest. She represents the police department's view of the case. She's provided you the discovery. You all can have a conversation about it. If you decide that you do not want to enter any type of plea to the charge, which is perfectly within your rights.
I could pay you guys money. What do you guys want? How much do you guys want? I'm gonna pay that shit right now.
That's not what I'm interested in. I'm interested.
I am, man, because I don't want to see you again. I want to see her again.
The charge is brawling. It's not that simple where someone just pays a fine and it's over. It may not be that simple.
There was a $50 fine on it.
No, that's the bond amount. That means if you had failed to appear, then you would have to post a bond of $50. That's different than a fine.
Man, I'll talk to her, man, because I'm just done with you guys, dude.
I need you to be patient with me because that's one of the charges.
I'm patient with you guys. You guys are never patient with me. The moment I do something dumb, you guys fucking put my ass lock up, get my ass charges. Never fucking patient. You never hear my side. So let's do this shit quick, man, and get it done with it. I'm not trying to be rude, but you guys have taken so much fucking time of my life.
But you are being rude. You're deliberately cussing and you're not listening. Well,
you know,
everybody here.
Like you would get frustrated with someone else out here, and you do what the fuck you want.
But I treat people with respect, and I expect you to do the same.
Well, I'm tired of you guys, man, because I didn't do nothing. And you guys are treating these other people that did harm me like fucking victims, like they're precious.
I've asked you a couple times to watch your language. I'm being pretty patient about it, but I want you to have a seat because if you said you wanted to speak with Ms. Keller, So if you can have a seat. When it's your turn to speak with her, you'll have the opportunity. And Ms. Keller, there are two charges that are pending. There's the brawling charge, and there's a second case that involves making unreasonable noise and use of fighting words. So the second case I haven't addressed yet with Mr. Bello.
Is the second case more recent than?
Yes. No, it's an older case, actually. So I can go through the history with you on that, but you'll just want to look at it and see what the status is for that older case.
And I just want to clarify. I know he was represented by Ms. earlier case. Is that?
That case concluded.
Oh.
Yeah.
No, we have not. He's not asked for public defender, but I want to make it clear to Mr. Bello. Mr. Bello, if you decide that you'd like the public defender to represent you, you can. I think he's saying he does not want the public defender to represent him. So you can have the conversation with Ms. Keller without counsel present. People that not supposed to. Michael Burns.
Morning.
Good morning, Mr. Burns. Pulling up the citation now. One charge for you. It's a charge of obstructing government operations, which is a violation of Section 551 of the Boulder Revised Code, occurring May 28th of 2025 at 28th and Baseline. A couple of different ways that we could proceed with that case. If you'd like to be represented by the public defender, you could meet with her today. You also have the option of speaking with a prosecutor about the case. You could do that with or without public defender representation. It may be a case that the prosecutors are willing to have participated through their community court program, but they have to approve that on this type of charge, but it's not an automatic process. What would you like to do?
I'm speaking with the prosecutor.
You want to speak with the prosecutor? Okay. And did you want to have public defender representation in connection with that, or do you simply want to have the conversation on your own?
Let's go with this conversation.
Just a conversation. If you change your mind, it just happens to be our public defender day. So if after talking to the prosecutor, boy, I'd really like to have her, or if you can change your mind in the next 5 minutes and say, I'd like to have the public defender represent me, I can appoint her to represent you. Does that make sense?
We might as well do.
You want to have the public defender represent you? Okay. So Mr. Lean, I'm going to go ahead and grant the request for Mr. Burns. The documentation shows that he's unhoused, so I'm going to find that he's eligible for public defender representation. We'll give him the application. So I want you to fill that out for us, just so we have it for our records. But to get the process moving, I'm going to go ahead and make the appointment, knowing that you don't have a substantial income, that you will qualify. So Leslie, if you can print out the indigency guidelines form for the defendant, he'll fill that out. We'll put that in the file. But I'm going to appoint the public defender. And then she can have that conversation with you and with the prosecutor about your case, Mr. Burns. Michael Burns, BY. So just go ahead and have a seat, and then they'll get with you shortly. I believe Michael Lau would be next. Remind me the names. Jesse, no, Jesse, right. Let's get, I need a face sheet for Jesse too. All right, Miss Keller, you're standing. Hang on a second, Mr. Lau. Miss Keller's standing, so she might have something to talk to us about.
Yeah, can we, Mr. Bell's trying to get to Cheyenne, so if we could call him.
Yes, we can recall Mr. Bello.
Thank you, Your Honor. I've had a conversation with Mr. Bello this morning. There is a deferred prosecution offer in the file. The only affirmative condition is that he complete mediation with Mr. Martinez. This is the alleged other party for this charge. I've told Mr. Bello I want him to make a good faith effort to complete the mediation. If the mediation does not work out, the city is willing to dismiss this case, but I want to see a good faith effort that he tried to complete it. I don't know if the other party will complete it. I know it's a two-way street, but.
And is that Michael Martinez that would be expected to participate? So different Martinez than I'm thinking of. Okay.
Yes, it's.
Okay. So, a deferred, and that's to the brawling charge in case number 2025-2616. So a deferred prosecution, Mr. Bellum, means that you don't have to plead guilty to anything. You're not pleading guilty to a charge. Have you taken a position with respect to the fees associated with that, Ms. Keller?
Your Honor, given this situation, Mr. Bello has had to move. He's traveling a significant distance to see his kids. The city's going to ask for a waiver of fines and fees.
Okay. So it's case number 2025-2616. There is a deferred prosecution offer in the file. The condition of the deferred prosecution is that you number one, not be charged anywhere in the next 3 months with a charge of a criminal offense that results in a guilty finding. And then the other condition is that you make a good faith effort to complete mediation through the Community Mediation and Resolution Center for the City of Boulder. So you'll be given their contact information. You're going to still have a quick meeting with Fernanda, who's our probation officer. She's going to give you the information for the community mediation folks. I don't get to decide what good faith effort means because I think you and Ms. Keller have had that conversation. But you're going to need to at least contact those folks and be willing to participate in a mediation. That's what you'd be expected to do. Based on the request from Ms. Keller, I'm going to waive the deferred prosecution fees associated with the case.
To be able to do it over Zoom. So, cool.
And it might be worthwhile for some follow-up from the prosecutor's office with the mediator so that they're familiar with what your expectation is. I wouldn't want to get a letter back saying that the person's failed to comply and then we have to address it.
I can reach out to them today and just give them a heads up.
That sounds great.
Yeah. Yeah, my sincere hope is that this will lead to a better living situation for everybody.
Okay, thank you for that, Ms. Keller. And then I want to just pull up the other case because there were two cases that were filed here. One is the older case. We didn't address that on the record, but I want to make sure that we have addressed it. This is case number 2024-2805. So back in June on that case, if you'll recall, you were in court. You, at that time, Mr. Bello, you pled guilty to a charge of making unreasonable noise. And I imposed fines and costs, suspended most of those fines and costs on the condition that there be no similar violations. I'm sorry, not making unreasonable noise and use of fighting words. And so there was a show cause order issued in that case. So I want to just check in with Ms. Keller on the show cause situation. It was scheduled for a show cause advisement for today's date. Obviously, the allegation was based on the new charge with the deferred prosecution. It's not technically resulting in conviction. So do you have a position with respect to how we should proceed on the old case?
Honor, since the new charge doesn't technically result in a conviction, I think the city should move on.
Okay, so there won't be any action taken on the other case. Thank you for that, Ms. Keller. I'll make a notation for our probation officer. CA withdraws motion for show cause. That case will remain open. Let's see, it was a suspended sentence for 12 months, so it remains open. Well, at this point, it doesn't because it was June 11th when you entered into that case last summer, and it was a 12-month suspended sentence. So my understanding would be that there would no longer be any conditions at this juncture on that case because the 12-month suspended sentence has now been completed.
That makes sense to me.
Okay. So that case can close. So just one case will be open. We'll have you meet with Fernanda. She'll go over all of this with you. She's going to give you the contact information. I'm going to waive a deferred prosecution fee, and you'll have to contact community mediation to go through the mediation process through the city. All right. Any questions for me?
Sir, apologize.
Thank you.
Apologize. for my
Okay.
mess.
I know it's emotional.
Just-
Down to see Fernando. Be polite with her, please. She doesn't.
I will.
be
You
hassled.
guys actually worked with me this time.
You know?
Thank you.
Yeah. I'll let you say it.
I'm going to call Jesse Nall, and we'll go out of order a little bit here because I want to get Mr. Nall back to his belongings, and he's been here for a little bit of time.
It's not even, it's way more official than that. I mean, I said it's the same conversations, stuff like that. I'm in a lot of pain. And I'll wait 2 months.
Okay. Well, you don't look well, Mr.
I
Nall.
went to urgent care like 2 days ago. They said you go to the emergency room with my dog. This, that, blah, 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 blah. So what have I done here? I'm going
I'm going to pull up the cases that we have for Mr. Nall. Case number 2025-2711 is the first case. Nick's ahead of me on that. But I'll probably want to look at the history because now into the public defender docket, so we may have appointed Ms.
I know there's a show cause advisement.
Thanks for that, Nick. I appreciate it. We'll start with case number 2025-2711. I'm looking at we're here on June 17th.
Yeah.
I rescheduled you to meet with the public defender for this morning.
I thought we just set my trial date.
What's that?
I thought we set my trial date.
Well, you may be. Ms. Talene is our public defender, so you'd ask for her to represent you, and that's why we rescheduled you to meet with her. If you decide to plead not guilty today and set for trial, we would be setting you our trial date. But right now, I want her to meet with you so you all can at least talk.
I really just set the trial date. I can talk to her. I'm sorry.
She has to be present. If she's going to represent you, she has to have her calendar out. So we set a date on her calendar. Tell me what's going on with you physically.
It might be my spleen. But after this, I'm gonna go take care of this. My biggest issue here is in November you ordered that I had to that I would have to get my ID and my social security card, which I've done. I've done my part. And just because they dismiss it doesn't mean that they have to, they have to fulfill their end of the bargain. When these people here that you guys recommended me to, did all this and that, whatever. The be there, our house, our roads, whatever they call it, crap now. They went down, saw me on baseline, and she said, "There's no more housing vouchers." And I said, "That is not true." And I said, "You show some things." And she said, "No, that's for for people who can pay the whole thing. You pay the whole thing." I said, "Now you're lying to me. If I can pay the whole thing, I wouldn't need a voucher." And then she goes, "Well, those vouchers for this. I know I checked for other people." I said, "So you mean that you didn't check for me?" And you guys said that you guys don't advocate or anything like this. And obviously, you guys do. You guys are showing favoritism. And this people I know for fact got a house and twice, and I haven't even got mine once. And I'm still out here. I'm doing the thing I'm trying to do, try to not get. I mean, I can't get a job.
Okay, let's.
I just think it's extremely rude and two-faced when they're checking for other people and stuff like that. I said, how many of those people that you were checking for are on the list after me? It's supposed to be the next man up. It's not supposed to be the people you show favoritism to. But they told me that they don't do anything like that to wait for my name to pop up on the list. My name is never going to pop up on the list because all the other people say they don't do anything like that. I do this for other people, and I'm still sitting here twirling my thumb saying, where's my house? I done my part. They have not fulfilled their part. Just because they dropped my charge doesn't mean they can just disregard your court order. They did last time I was here, they were supposed to show you what they have been doing to help you with my housing, which is nothing. I did my part, they have not done theirs, and I'm still out here and all sorts of stuff like that. And my stuff might be gone. Because I told her it might be at the most an hour. She'd be out there right now for 2 hours. I said, it's like I'm in a lot of pain, I might find a yell.
Take a deep breath. Take a deep breath.
They've done nothing for me. They told me they don't do anything, but they do that for other people. And tell me I have to wait for my name to pop up on the list. That's never gets done yet.
We've had this conversation a few times. I want to make sure it's clear to you. Our navigators can't promise anything. They work with people. They try to hook you up with other people who have the ability to provide vouchers. The voucher system isn't just who's next on a list. It's which people qualify under state and federal guidelines for the vouchers. And so
homeless. I'm actually homeless.
I know you are. I'm not saying you're not a person who might be certainly benefit from it, but our staff, Mr. Null, you're not listening. Let me speak and then I'll, because if you can't really understand what I'm saying if you're speaking, there's no way for you to do that.
Absolutely.
Our staff, our navigators, Sebastian, Dara, Nick, they try to get people qualified for housing. That's definitely a goal that they have, but they do not have the ability to determine your eligibility. That's through other agencies that decide whether you're eligible for housing. So if they walk you through the steps to get the process moving, it doesn't mean that you're automatically going to get housed. I wish it were that simple. I wish there was housing for every person who truly needed it, because there's a lot of people who truly need it. It's not as simple as we would like it to be. So I want you to understand that they're doing the best they can by getting you involved with the process, but they do not control the outcome.
Yeah, they didn't even tell me that. They didn't tell me I had my housing assessment in November. And I didn't even know that was going
Who
on.
are you working with?
This guy right here.
With Mr. Stan.
And so since then, and he's just been, well, we're just waiting for your name to pop on the list. He didn't tell me I need to go talk to anybody. I had to figure this out on my own. I had to get to the other people. Nobody told me I had to contact anybody.
Okay.
This was like 5 months later into it. After my housing assessment was already done, I was just told I'm going for my name to pop on the list. He didn't say I had to do anything. I didn't understand. I still understand how this housing process works, but I do know that all these people keep telling me that they don't do anything, people like that, but they always do, and they end up doing that. If he can't do it, that's fine. But they should have told me I should have been more proactive about this the moment they sat there and did my housing assessment. And they did that. They did not do that. It's almost a year later. My dog situation and this and that, blah, 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 is the direct result of people not telling me what I need to do. But trust me, I would have done it. I would have paid people. I would have had my dad pay people to help me figure out how to do this stuff. Not to prove retarded on it.
Are you asking to have some follow-up work with our navigators? Would you like to have another conversation?
No, because every time somebody talks to them, they keep telling me the same thing. We don't do anything. We can just wait for your name to pop on the list. And last time I was here,
if you fulfilled
what they've been doing,
that may be true. It may be at this point that you've done everything that you can do, and you're still not eligible for the voucher. It may not be that you qualify yet, or that there's others who qualify who've already fulfilled the process before you. So
what process? What do I need to be doing?
Well, I don't know exactly, because you've said you did a housing assessment. There may be steps that are further required. That's why I asked if you'd like to have a conversation with a navigator. They can at least tell you where you stand with respect to the documentation that's been provided. But they can't do anything if you don't have a conversation with them.
Well, I keep calling them and contacting them.
Who do you talk to?
This man.
When was the last time you talked to Nick?
The last time I was in court, they were supposed to go be checking out my housing and stuff, see what stuff it was, and then they never came.
Let's have you meet with either Dara or Sebastian today to see where you are with that. But let me make clear with you that you were here today. Not on one of those situations. You're here today because you have an aggressive animal charge that's pending against you. You asked for the public defender to represent you. She's here meeting with someone else. She will meet with you shortly. If you're not able to do that because you're in so much pain, I'm willing to continue your case one more time, but we have to have at least have Miss Talin in the courtroom so we can find a date that works on her calendar. All right. Would you like to do that, or do you want him to try to move forward today with her? She's outside speaking to someone else, to Mr. Lau.
I'll just wait till she comes in so we can just set a date.
Okay. So go ahead and have a seat. I'm going to let her know. I'm going to let her know that you're here, and then she can talk to you about your cases.
I just want to be able to set this over for like next week or something like that, so I can whatever, because I had to go in there. But I went down to urgent care. They said, no, you gotta go to the emergency room.
When she comes in, I'll let her know. We can just get you reset so that you can get to urgent care. So as soon as she comes in, I'll try to get that.
Well, they still got to go to the emergency room.
Okay. So let's get her in, and then we'll go from there. Okay. So just remind me soon. Ashley comes in, we'll call Mr. Null.
Thanks for your patience with me.
You're welcome, Mr. Null. I hope you get some relief from that pain you're in. Miss Talin, before we move too far along, I would like to just call the Jesse Null case. He's scheduled for you to meet with you today.
Okay.
Mr. Nall's just in a tremendous amount of pain.
Okay.
And he's got aggressive animal charge in case number 2025-2711, and then a trailing case with that also was an aggressive case that was a previous plea on.
Okay.
Rather than you and he have a substantial meeting today, I'd like to reschedule, but I didn't know that if you had a date where you could come sooner than a month out.
Yeah, my July is actually pretty clear because I was supposed to be in trial and it went away.
Could we do next Tuesday at 9:30? Is that possible?
Let me just double check just to make sure. Yes, I can do that.
So we're going to reset both of those cases for.
I'm gonna give you my card. Do you have a way to contact me? Because if you're in surgery, I can do something. I can file something with the court. Okay. Okay.
So let's make sure that we give Miss Alina setting notice as well for that one, so she can, because it's not typical for her to have to come back on next Tuesday. So we want to give her a setting notice so she gets it to her calendar.
Okay.
So let's. I'm going to have Leslie. Do you think you could print out the setting notice from where you're at?
I can.
Can you print out two and just give one to Mr. Nall for both cases that he has pending? We'll need setting notices for both of those for next Tuesday, July 15th at 9:30. There isn't a slot there normally, but 9:30 is a good time to have our public defender come in and meet with you.
Yes.
Okay, Mr. Nall. So we'll see you next Tuesday at 9:30. Hopefully you'll be feeling better. Okay. Yes, I think so. Just have a seat there. And then if you need to call from the building, someone can call and you can wait safely here. I know you got your belongings outside, so you're worried about that too. But I'm worried about you that you're not getting the care that you need.
Obviously, go outside, tell her the way she wants at this point. But that's what you
You don't, but you got to stay seated because Leslie's going to print out your setting notice for your court date next Tuesday. And as soon as you have that, you're free to leave the court. Okay. You may have that for the district court.
Yeah.
The state. Okay. So I'm sorry you're in such pain having to do that. Let's go get her. It's a case. This case. I'm on camera. I believe we're on the record. Is that correct, Leslie?
We're on that.
Thank you. Mr. Burns is back. He's standing next to Sebastian. Go ahead, Sebastian.
Thank you, Your Honor. I had the opportunity to speak with Mr. Burns about his case 252607, obstruction charge. We explained the deferred judgment process, and he seemed interested in moving forward with it. We've completed 2 out of the 3 tasks, and the third one to be completed by this Thursday, where he'll be meeting with me in community court.
Oh, terrific. Great. Thank you for that. So, Mr. Burns, I think I mentioned to you that the process is a little bit different with charges like obstructing government operations, but ultimately can result in a resolution of your case where you can earn a dismissal of the case, and you're close to getting to that place. In this particular circumstance, the prosecutors would want you to plead guilty to the charge of obstructing government operations in a deferred judgment perspective. And that means, unlike the other cases that you may have had with us, which may have just been dismissed outright, this one will stay open for a period of time.
Okay. Deferred.
That's right. It's deferred. And so ultimately it can still be dismissed. And the deferred judgment agreement in the file that I have indicates that you would plead guilty today to that charge. The case would stay open for 6 months. If you can go through that 6-month period without any charges involving violence, threats of violence, or obstruction. And I'll just ask the prosecutors to kind of look at that document as they go forward. I think you mean obstructing government operations, but or maybe you mean both. But I've seen a few times where I see obstruction, and if you mean obstruction, that's okay. But it's different than obstructing government operations. So, that would be great. And so I'll go over it with you. But you couldn't have that charge again, Mr. Burns, which is to be able to move your tent within the 72-hour period that you were instructed to move it. So that's one of the conditions. And then the other are the ones that you've been working on with Sebastian, is to those 3 housing-related tasks, 2 of which are already done. You're going to finish the third on Thursday, hopefully at community court.
I'm going to go today.
Oh, okay. Is that what the next step would be? Perfect. Okay. So when you plead guilty, you are giving up your right to trial and all the other rights that you have in our court. Do you understand that? Are you doing that voluntarily?
Yes.
Is anybody forcing you to plead guilty? Are you under the influence of any medications or drugs or alcohol?
No.
Do you understand this charge of obstructing government operations?
I do. And they understand now that I was the one that was cleaning up after everybody, and my stuff was the last one.
Okay.
And so they haven't. They're actually beginning to really appreciate the fact that I've been around. In the morning, because I cleaned it all up. They just said, "Oh,
Okay.
what?" Then you go,
And I'm looking at the police report. I'm going to find that there at least was a factual basis for the charge. So
Yes.
and then the other questions for you revolve around whether you want counsel to represent you. You're moving forward without having public defender working with you. Although, Ms. Talene, did you all have a conversation or not?
We did have a conversation, but this is how he wanted to proceed.
So he's proceeding without benefit of your counsel,
Yeah.
but you've at least had a conversation
Yes,
with him.
I have had a conversation with them.
Okay, so I'm comfortable that you've had the representation that you might have needed, but want to understand that you make sure you understand. If you wanted to have the public defender work with you and plead not guilty in separate trial, you'd have that right. Do you understand that? But you're comfortable proceeding as we're doing? I am going to find that it's a free and voluntary decision to plead guilty. Let me go ahead and accept that guilty plea. It is to the charge of obstructing government operations, which is a violation of Section 551 of the Boulder Revised Code. And that allegedly occurred on May 28th of 2025 at 28th and Baseline. How do you plead to that charge?
guilty.
I'll accept the guilty plea. We'll place you on the deferred judgment for the 6-month term. I'm going to waive the fees and costs for the deferred judgment. And then you'll have 3 housing-related tasks to complete. The next step of this process is to meet with our probation officer, Fernanda. So we're going to have you go down the hall. Also something you probably haven't done before, but you're going to go 2 rights and a left down the hall. She's going to have a really brief meeting with you, get your signature on the deferred judgment agreement, make sure you understand how it works.
Yeah.
And then Fernanda and Sebastian will be talking. He'll confirm with her when you've completed that other task. And then at the end of the 6 months, she's going to pull up your criminal history to make sure there haven't been any other charges of obstructing government operations or charges involving violence. If there have not been, she's going to withdraw the guilty pleas that you entered today and dismiss your case, and she'll also seal your record.
I remember that.
Okay, good. I'm glad you understand. So if you don't have any questions for me, I think the next step is to get you down to see Fernanda. Can you walk through the handoff there?
Yes, Your Honor.
All right, thank you for that, Sebastian. And there's the face sheet for you, Leslie.
Thank you.
All right, thank you all. Thanks for all the work today. I have not seen you in person for a long time, Ms. Keller. It feels like.
I think we're ready to go again, Judge.
We are on the record in 2025 CR 311, State of Kansas versus Gavin Lane Vickery. Please announce appearances.
May it please the court, the state appears by Judge Gillette County Attorney.
William
we also-
McLennan for
Go
William McLennan for the defendant, Gavin Vickery, who appears from the Greenwood County Courthouse.
And then we have subpoenaed witnesses for the state, Jessica Morgan, CSO 1, Sarah Wheeler, Chief Court Service Office, and Jerry Wallace, I understand, of the Battery Intervention Program. Is that right, Mr. Wallace?
Yes, ma'am.
Okay, thank you, sir. Mr. McClendon, we are here on a warrant to show cause why your client's probation should not be revoked. Does he wish to challenge and have an evidentiary hearing?
No, Your Honor, we'd stipulate to a probation violation here today.
All right. Mr. Vickery, do you understand that you're here because the state is seeking revocation of your probation?
Yes, Your Honor.
You understand that they're saying you failed to pay your court costs and fines in the amount of $813 with no payments at the time of the filing of the motion.
Yes, Your Honor. But those fines are paid now.
They're paid now, they weren't at the time.
Yeah.
And you've paid the full 813.
Yes, Your Honor.
Do you understand they're also saying you failed to complete special conditions of your program? That is, you failed to comply with a no contact order?
Yes, Your Honor.
That you failed that you in fact had contact with a Grace Terrell Vickery and children after, and you weren't supposed to do that?
Yes, Your Honor.
You were supposed to obtain a batter's intervention evaluation and follow its recommendations, including an orientation and 24 weekly classes. They're saying you didn't do that. You understand that's what they're saying?
Yes, Your Honor. I have been attending my classes. I did the orientation. I did all of it. I had missed one class.
Had you done any of it at the time the motion was filed?
Yeah, I did it all when I was told to do it.
All right. So you said you do or do not want to have an evidentiary hearing and make the state prove whether or not you did violate as alleged.
I do not.
Your Honor, if I may.
Yes.
We'd particularly be stipulating to the allegations raised on the no contact order. My client had contact with Grace and was the one who made the report to his CSO that he was having the contact. Therefore, we kind of figured between the two of us that we would not waste the court's time here today and fight that specific allegation, since he could be revoked on that as well. And we would ask for the court's mercy and hoping to be reinstated on probation.
All right. Well, let me follow up on that. Do I understand correctly that not only did he have contact with the victim, but there was some kind of subsequent altercation or altercation in which he caused her to be ejected from a vehicle and end up in the Labette County Hospital in ICU?
I wouldn't say that I caused her to. She had jumped out of the vehicle while I was driving.
And was it during an altercation between the two of you?
Yes, Your Honor.
Okay, so not only did we have a violation of the no contact order, but we had some kind of altercation in which she ended up out being ejected from the vehicle. Whether she did it voluntarily or you did it to her, she was ejected from the vehicle and it ended up in ICU, Labette County Hospital. And according to the affidavit, the defendant was told multiple times by his probation officer that he was to have no contact, but continued to do so. So this was not a one-time contact situation. Are you agreeing to that, Mr. Vickery? That it happened several times at least?
Yes, Your Honor.
Okay. Now, at the time the petition was filed, May 13th, 2025, or the motion, you had a balance of $813. Do you agree to that?
Yes, Your Honor.
But you've since paid it off, so you have a balance of $0. Is that what you're telling me?
Yes, Your Honor.
And at the time the motion to revoke was filed May 13th of 2025, you had obtained the batter's intervention evaluation, is that right?
Yes, Your Honor.
But you had not completed, at the time of the filing of the motion, the orientation or the classes.
I had finished the orientation. I think I did the orientation in April.
Okay, and you hadn't started the classes yet?
Yes, I did. I started the classes a week after orientation.
Then do you know why the county attorney would say you didn't? Did you provide any proof to the probation officer that you were doing that?
I had told my probation officer, and I think Jerry was in contact with her too.
All right, so Mr. McClendon, he's denying that part of it.
Yes, Your Honor.
Ms. Morgan, as an officer of the court, tell me, did he give you any proof that he had done the orientation and started the classes?
Your Honor, if you are reading from the request for revocation, it's simply stating that he completed the evaluation. He obtained a batter's intervention evaluation and was recommended to attend the BIP orientation and the 24-week BIP classes. That was just information for the court of what was recommended for the defendant.
All right, so you're not stating that he violated in that regard?
No, Your Honor.
All right, well, I see I was reading from the state's motion, and I see you did file something separate here.
It in ours says the same thing, word for word, that he obtained the evaluation, was recommended to attend BIP orientation 24 weekly classes.
All right. So I do find that the defendant knowingly and voluntarily waives his right to an evidentiary hearing and stipulates to violating his probation by failing at the time of the motion to make any payments, and that he seriously failed to comply with the no contact portion. And at this time, he is found in violation of probation. Recommendations for disposition, Ms. Gillette?
Your Honor, in this case, the no contact order was a paramount part of the sentence. Ms. Vickery Grace wanted to have contact with him again. She was told, no, you can't overturn a court order. You can't have contact with him. He was told multiple times, you cannot be having contact, and that it wasn't in his best interest. He asked the BIP people to try to get it undone. He was told he had to have a motion for the court to reverse this order. It then ended up in a result of situation where Grace jumped from a moving vehicle during an argument and ended up in the ICU, and he continued to be in the ICU with her after this incident. And I ended up having to send a copy of the court's order saying the no contact continued over to Labette County, and they made him leave, and told him that there still wasn't time. The other thing that is extremely concerning to me is that he missed his appointment with Ms. Morgan, and I've been provided his text messages with her because he wanted to come in and see, and she said, you missed your appointment yesterday. I have appointments all day today, tomorrow at 9 a.m. So then he continued to text her. She's in the middle of stuff the next day, and she said, can I call you later? And he continues to text, and when she gets a moment, she says, FaceTime at 9:30. And he kept asking her for a court date, and then admits that Grace.
What date of the month was that?
That was in that was April 27th when he asked her for a new court date. It was April 8th and 9th that the conversation was happening about missing his appointment. he was not to be having contact with her. And then he was begging to have contact with the children. And he was told, you need to contact your attorney. And then once he is arrested, his mom starts texting rude and intimidating texts to Miss Morgan, to the point Miss Wheeler was asked to take over the case as the chief CSO instead of having Miss Morgan deal with it. And so I don't think that that's the kind of behavior that someone on probation should have. It's like he doesn't want to take responsibility for his actions, thinks he doesn't have to follow the court's orders, has shown that he's going to miss his appointments, walk through the restraining order, and didn't pay until after he was arrested. At this point, I don't have another choice but to ask for him to serve as underlying. He's not taking responsibility for his actions, and the actions resulted in very graphic photos that have been sent to the state of Miss Terrell's Vickery's injuries that she sustained from being in a moving car with him and jumping from it to get away from him. His choices are what has put him in this position. He made the choice to continue to have contact and have altercations with her. He made the choice to not pay his fines. He made the choice to be missing his appointments with his CSO. These are his choices, and I have no other recommendation but for him to serve as underlying.
Mr. McClendon, your recommendations?
Yes, Judge. My client obviously admits wrong. That's why we first admits that he was wrong and is trying to take responsibility for his actions. That's why we did stipulate here today. We can't hold Mr. Vickery liable for the actions of his mother, and I believe the basis for those allegations may have revolved around Miss Vickery's mother stating she wanted to report Miss Morgan to the CSO Ethics Commission. Again, I don't know what that was about, and it wasn't included in any discovery, so I would object to that being used in any kind of weight in this for the purposes of a warrant to show cause hearing. Additionally, Judge, my client admits he is wrong. He was engaged in BIP classes, and he is the one who reported the contact to his CSO. I do not know if it would have been found out by Miss Morgan eventually or not, but he did take responsibility for his actions there as well. I do think Mr. Vickery is trying to turn his life around. He understands he did some things wrong. He currently does have a job, a very stable employment with Sidecut over in Neodoshe. He was able to make a lump sum payment of $813 to pay off his fines. I understand he should have done it earlier, but this case is a 2025 case. And I do believe looking at it here, the journal entry on this case was filed in March. So it has been approximately 4 months since the journal entry was filed in this case. So to pay a total of
Let me stop you right there. My order, as reflected in the journal entry, was that he pay a 12th of the total due each month. And even though there hadn't been very many months, he was supposed to make the first one March 28th. He would have had at least another one after that, and he didn't pay any. So
understandably so,
okay.
Judge.
Okay.
But again, he was able to get it together and pay the full amount off. And
How did he do that? Was that through his mother?
I do not know, Your Honor. I assume it's probably through his employment.
How'd you pay that off, sir?
Yeah, you are correct. My mother did, and we're keeping tabs on everything so I can pay her back.
Okay, go ahead, Mr. McClendon.
And really, Judge, we're here today to try not waste the court's time in asking for a warrant to show cause hearing. I mean, he knows he messed up, and we're asking for some mercy from the court here. So, and that he not have to serve his entire underlying, possibly a week or two in county, and then he can be released again to try to successfully complete some VIP courses.
When did you do your BIP assessment? The assessment?
I think it was in April. I don't know the exact date.
In April. Well, I
Judge,
go ahead, Ms. Gillette.
the copy was March 14th, 2025 with a signature date of April 14th, 2025. So I believe he did it March 14th. And then it was transmitted to us in April, but the actual date is March 14th. And I do believe Ms. Morgan found out about some of the ICU stuff because Ms. Vickery's parole officer, probation officer contacted her.
Well, on February 28th of 2025, I ordered that he make the phone call and get into the appointment within 14 days. I don't know that I can tell from what you've told me whether he did that or not, but at least he was in there shortly. Not too bad. He didn't do too bad on getting the evaluation. But that's not what we're considering. We're considering the fact that he was ordered as early as February. Well, he was ordered as bond, and then he was ordered February 28th to not have any contact. And I understand he had numerous contacts with the wife and children, but notified court services as soon as she was in the ICU again. Ms. Gillette, remind me, this had originally been an aggravated battery case pled down. What was her original injury in this case that caused it originally to be filed as an ag battery?
There was she was angry with him and threw her phone on the ground, cracking it a little bit. He proceeded to grab her by her hair and hit her in the face with her phone. There was an abrasion in the middle of her forehead with multiple small cuts surrounding the area. That was the first part of it. There had been an incident where she had advised that he had fractured her ribs, and that she had gone to Fredonia Regional Hospital. She had refused to make a report, but was told they would contact the Greenwood County Sheriff's Office. That was a different case number and date. And so the aggravated battery was fracturing her ribs in the prior incident. And then this incident, he took her phone and smashed it into her face. It's pretty graphic things for children to be watching or seeing, and people to.
Children were witnessing all of this?
No, Your Honor. It was in the police report that the children were not there.
The children were who he was supposed to be babysitting, according to the report.
Well, with this kind of history, I have no doubt the children have seen way too much abuse. At this time, I do revoke the defendant's probation. I order that he be taken forthwith into custody and confined by the sheriff of Greenwood County until he has completed the balance of his 6-month sentence. Of course, he will be entitled to credit for all time served to date. And I would hope he would take advantage of the programs that the Greenwood County Sheriff does offer. I know that the sheriff offers a fair number of programs that could benefit a lot of people, and hopefully they have some that will benefit this man. It just sounds like this woman is on borrowed time as long as she's with this defendant. And I will maintain the no contact while he's in custody with the wife and the children. Anything further from either party?
Your Honor, I would ask that the no contact for the kids at least be lifted. My son he's 9 months old. I mean, he's just about to start taking steps. I really don't want to miss that.
Well, I appreciate that, but I'm going to deny that. I mean, you've almost killed his mother a time or two, it sounds like, or she's almost gotten killed while she's with you. And I think until you get some more counseling under your belt, you probably shouldn't be around these kids. I don't know now. Mr. Wallace, what are your credentials? Your education?
Well, yeah, I'm certified with the Attorney General's office, Judge, and I've been doing this for about 10 years. I was a probation officer in the 31st for almost 20 years. So the defendant was reluctant to take any responsibility and didn't really want to participate in the program until he was arrested for the second incident. And then he totally made a 180-degree turn and has been participating in the program. And at least what I've seen, I mean, what they do in class and what they do outside of class, I have no idea what they're doing outside. But he's at least made an impression that the court did get his attention when they arrested him and held him on the first, when she was first taken to the hospital.
Okay. Do you have any recommendations on the contact with the child or children? I mean, they would have to go to the jail to see him.
But they don't do in-person visits. They only do visits over the phone,
Oh, okay.
FaceTime.
All right. So and I'm looking at it now from the child's perspective. Do you feel qualified to say the effect of the child of not seeing his father versus seeing his father?
Yes, and I would say it would be better, especially if it's through Zoom or online, that they'd still have contact, so that they would know that her father hadn't written him off, and he still cared for him, even though he's demonstrated a level of violence which wouldn't be healthy for anybody in the family, obviously. But maybe he could show some remorse to them during those contacts as well.
All right. And Miss Morgan, which of you or Miss Wheeler, spent more time with him directly?
In the past couple months since his mother got involved, Miss Wheeler has gotten involved. So I would say I have been in more contact with him.
Okay. And do you have, what's your position on the child seeing him by Zoom or whatever method they use?
I agree with Jerry, Mr. Wallace. I do believe that he should, his son should still be able to have contact with his dad outside of their own relationship issues, if it's supervised.
Supervised. That's
not by his mother, of course.
Not by grandma or mother. Okay. How's the mother doing now? Is the defendant's wife or quasi-wife, whichever? She's not still in the hospital, is she? Anybody know?
Last time I knew, Your Honor, she was not in the hospital. I have not heard. I can't say the last time, but I know that she was released.
All right. Ms. Wheeler, anything you want to say or add to any of this?
No, Your Honor, I'm in agreement with CSO Morgan and Mr. Wallace.
Okay. Any Mr. McClellan or McClendon, I know you'll be in favor of contact. Miss Gillette, anything you want to say on that issue?
Judge, I asked to be supervised by someone other than Grace Terrell. I don't know if she's using Vickery. I would say that any visits need to be supervised visits that are Zoom only or the video chat only.
All right. Well, looking at it from the child's perspective and considering that in 6 months he will have flattened his case and I will have lost my jurisdiction over him, I think what has been recommended about continuing the relationship makes a lot of sense. So I will go ahead, kind of reverse myself on that. I will allow contact with the child if it is by Zoom or phone, if the jail is willing to supervise it to make sure there's nothing inappropriate. And that's by the jail. I still order no contact with the mother, absolutely no contact of any kind. And the grandmother is to cease and desist trying to make life miserable for court services. If she's still doing that. The grandmother, I should qualify that. The grandmother and the mother. So anything else we need to specifically address, counsel? Or anyone else for that matter? All right. We will be in recess. Is there someone there, court security, to escort him to the jail?
Yes, Your Honor, we have somebody here.
All right, thank you. This matter is adjourned. Thank you all for your time.
All right, this is cause number CR 22-368, State of Texas versus Seth Edward Atkins. All right, Mr. Atkins, the state has filed a motion to adjudicate your guilt and to revoke your community supervision. I want to take a moment and display on the screen their allegations before we have a conversation about whether or not you want to proceed and represent yourself. Okay. Just a moment. Can you see that on your screen?
Yes, sir. Oh, okay. Can we go back up? Do it tomorrow.
Hey, I don't want you to say anything. I just want you to read.
Okay. Yes, sir. Yes, sir.
All right, so Mr. Atkins, I don't want you to say anything other than to answer my questions that are going to be limited to the discussion of whether or not you want to represent yourself. Now, that's been indicated to me by Ms. Tabraham in your own words without telling me anything about these allegations or your case, why it is that you want to represent yourself.
I don't really trust lawyers anymore. And I'm more than qualified to represent myself, like Mr. Martin.
So tell me, why do you not trust lawyers?
Good book says that they're bought and paid for. Bought and paid for, man.
The good book being the
Holy Bible. The Holy Bible.
And where does it say in the Bible that attorneys are bought and paid for?
Jesus had a whole conversation with a lawyer who searched after his own righteousness and showed him the way.
And Jesus in the red word said to be weary of lawyers because they're bought.
Don't trust them.
It says don't. And where does it say that?
Do you want me to get it for you?
Yes.
Mark, can you please look up which verses, I know it's in Matthew and John, but I want the good one where Jesus has the conversation with the lawyer.
You have to be careful not to take person.
I know. It's all about just seeking after your own righteousness and how all sin is evil. This Bible, right? It's not just in the Hebrew Bible?
It's quite a few verses.
It's a bunch of them. I don't know if King James and the Council of Nicaea decided to take out that part or not. Sorry, Mr. Martin.
Okay, take your time.
Yes, sir. I'm sorry for all of this. I really am.
Okay, take your time, find the verse, find the scripture that you've found into.
Not in the way that, it's not in the way that all of them are bought and paid for. But I know how bureaucracy works, and
Well, I don't want to get too far from what you said earlier. You said that the Bible says, that God's word says, do not trust lawyers because they are bought and paid for.
it's because the law, men of the law search after their own righteousness.
No, sir, no, sir. You said that that's what the Bible says, and that's one of your grounds for why you want to represent yourself. You read to me the book of the Bible, the verse, the chapter, and I want to know if it's Jesus's words or if it's someone else.
Yes.
And if you don't find that and that's not in there, then you come back and you tell me it's not in there.
Yes.
Move on to the next one, but I don't want to move into talking about self-righteousness and bureaucracy. So go ahead and sit down and read through the Bible and tell me where it's at and tell me when you're ready.
I can see the
Hey, Your Honor.
Go ahead, Mr. Atkins.
Okay. So the verse has been taken out of this Bible. In the Hebrew Bible, it's in there. I know where it's at. If I had my scrolls and stuff, I could show you.
Where are those at?
At my house. So if you want to give me a court-appointed attorney, then go ahead. Please, sir.
Do you want a court-appointed attorney?
I just want y'all's help to fix all this. But yes, I would.
Okay.
I would like a
Well,
court-appointed.
you told my coordinator there that you wanted to represent yourself. And you do have a constitutional right to represent yourself. However, as the judge, it's my job to ensure that you are adequately warned about the dangers of doing so. So I wanted to give you an opportunity to tell me why you wanted to represent yourself. And obviously, that's the first thing that you've said to me is that you have a religious belief that that Christ said not to trust lawyers because they're bought and paid for. Can't prove that to me, then we can go on and we can talk about your other points. We can talk about your education, we can talk about your legal training, talk about your familiarity with the rules of criminal procedure. We talk about the advantages, the disadvantages. We talk about your rights. We can have that discussion. I have no problem with it, but I want you to be heard first. And then it's going to be my opportunity to evaluate whether or not I think that it's appropriate for you to have a court-appointed attorney. Or rather to represent yourself. If you insist on representing yourself, then I will do my job and I will go through the threat of warnings and I'll weigh that, I'll make that decision. If you're telling me that you have a natural distrust of lawyers, okay, that's fine. But you understand, Mr. Atkins, though, that even if an attorney is appointed to you, you make the decisions on what you want to do, whether you want to play true to something, play not true to something. You and you alone get to make that decision. No attorney gets to substitute their decision for your decision. So you are in control. The attorney works for you and helps you to understand the law, and helps you understand the weight of the evidence, it helps you understand how to make an informed decision. based on the allegations against you. Now, we find that you're indigent and that you are eligible for court-appointed counsel. If you want court-appointed counsel, that attorney will be appointed to you, and then you can discuss the case with them. And then they come and obviously they make the arguments before the court, and they are your representative in court. And at this point, you have an opportunity to have one of two things. You can either negotiate some kind of agreement to resolve the accusations, or you can request to have a hearing in which the state of Texas through their prosecutors will be, they'll bear the burden of proving the truthfulness of the accusations beyond the preponderance of the evidence. It's a lower burden because it is a revocation and it's not a trial on beyond a reasonable doubt. And if they approve that, then you could be revoked and sentenced anywhere from minimum 2 years up to 10 years in prison and a fine not to exceed $10,000. Some of these things I know that you're already aware of because we had this discussion before you were placed on 10 years of deferred adjudication. So what, if your position is you want to represent yourself, then let's carry on. We'll talk more about it. If it's not, that you do want the assistance of counsel, then let me appoint you an attorney and then let's carry on.
Can I just ask you a question, Judge Martin?
You can, but I don't want you to say anything that could be used against you in court, okay?
Okay.
All right, go ahead.
You know, I'm not one to let people just keep pushing me around. You know what I mean? Like, I do freak out. I mean, I do lose my cool sometimes, but it's never been without justification. You know what I mean? Like my grandmother's husband pulled a gun on me. I got aggravated assault charges behind it, all because he still to this day bullies my Down syndrome uncle, who hates living over there now. And I can't be there to protect him because of him. You know what I mean? And try to tell y'all that he pulled a gun on me. My grandma told y'all he pulled a gun on me. Nothing ever happened. Got picked up on this charge. Someone tried to steal my truck, hit me over the head with a bat to where I'm bleeding down my head. No one ever bats an eye. Doesn't ask any questions about who hit me, why they were trying to steal my truck, whether or not I want to press charges. I've always had y'all's back and y'all never had mine.
Well, Mr. Atkins, there's nothing in the motion to adjudicate about new charges, about an assault. There's nothing in there. It says that you didn't show up to probation, you didn't pay your fees, you didn't do your community service, you didn't take a class. It has nothing to do with any of the things that you've mentioned, okay? So at this point, to resolve those, if you have evidence that rebuts that or mitigates that, then that's where we have to get to in the process. And the only way to do that is either represent yourself with the court's permission, or have an attorney that works on your behalf that you give information to, and they argue to the court how you're not legally liable for these charges, or that they should be mitigated because of your circumstances in life. That's what we're trying to get to. Obviously, today is not going to be a resolution. Today's not the resolution. Today's not the hearing for that. Today is what we call a pretrial type hearing. And so the only issue before you and me right now, Mr. Atkins, is who's going to represent you? Is it you? Or is it going to be an attorney that I appoint to represent? And I just need to know, if I appoint an attorney, are you going to work with them and do your best and let them represent you? Or are you going to be difficult and grieve them and file complaints and make accusations?
I've never given y'all problems like that, Mr. Martin.
I'm not saying you have, Mr. Atkins. I'm not saying you have, but I'm just saying I have to ask that question, because if you believe that there's a religious conviction that you should not accept the help and assistance of an attorney, that may be an underlying motive for you to not work well with an attorney. So I like to know these things going in. And of course, I've been in this position many times, and so I've learned over the years to ask these questions, because I've seen this become an issue.
with people in the past, and I just need to know if that's going to be you, then let's don't talk about having an attorney. Let's talk about representing yourself, and if you're going to be able to do so intentionally and knowingly, that you got that you're forewarned on the disadvantages of self-representation.
No, I guess. Will you please appoint me an attorney?
Yes, I will. I will do that. So, Ms. Taberham, do you need any paperwork from Mr. Atkins?
He's not completed the affidavit, but
Go ahead and have him complete the application.
okay.
I think I already know what the finding is going to be, but we do need this for our compliance with state law. So fill out the affidavit of indigency, request for court appointed counsel. Let us review that. If you meet the qualifications, and I'm pretty confident you will, then the court will appoint you an attorney. I believe in your underlying case, you were represented by Mr. Jeff White. Is that correct? And I believe, I think I remember that's someone that your family members hired for you. Is that correct?
Paper out of my money, but yes, sir.
All right. Do you have money to hire an attorney?
No, when I went to prison, I gave my mom the rest of the money that I had. She blew it.
All right, then just go ahead and fill out the paperwork, and then let Ms. Taberham tell me where we stand on our appointment process. Okay.
Sure.
All right, you can go ahead and have a seat. You don't have to stand.
Okay, we're ready, Your Honor.
Okay, come on up, Mr. Atkins. All right, we are back on record. Cause number CR 22-368, State of Texas versus Seth Edward Atkins. All right, Mr. Atkins, the court, having reviewed your application, finds you to be indigent with reimbursement. So that means that you may have the financial ability to reimburse the county for any fees paid on your behalf to Mr. Schmidt, who's been appointed by the court to represent you. Court will reset your case today. We're going to reset to August 28th. Court has appointed the Honorable Richard Schmidt as counsel. Mr. Atkins, I want you to work with Mr. Schmidt. All right. He's a very good attorney. And I know Mr. Schmidt, have known him for many, many, many years now. And I can tell you that you've made a good decision today. You've received the appointment of a very good attorney and one who's also very well versed in scripture. So any questions or thoughts or concerns that you have, I'm confident he'll be able to walk you through those as well. Okay.
Thank you, Judge Park.
You're very welcome. We'll see you soon.
Yeah. So.
Okay, Your Honor, I believe that concludes our docket out here.
Okay, that does conclude everything on the court's criminal docket for the afternoon. The court will adjourn. Thank you, Mr. Hernandez. Thank you, Mr. Hartwell. Thank you, Ms. Taberham. Thank you, Mr. Schmidt.
Thank you, sir.
Thank you, sir.
All right, I have an individual seated at the Judicial Center Zoom location. I trust that's Joshua Albin.
Correct.
It's the State of Kansas versus Joshua N. Albin, case number 2025 TR 1036. As announced earlier, Amber Norris is appearing for the county attorney's office on this docket. Mr. Albin, I have before me an active warrant for your arrest in regards to an unresolved charge of drag race or exhibit of speed, an unclassified misdemeanor, which would be punishable by up to 30 days in the county jail and up to a $500 fine or both. How do you plead to this, Mr. Albin?
Not guilty, Your Honor.
Court will accept the plea of not guilty. We'll set this case for further proceedings. Do you intend to represent yourself on this, or are you going to want a lawyer's assistance?
Probably a lawyer's assistance.
All right. Do you have the money to hire your own lawyer?
No.
Are you working currently?
Correct.
Okay. Where do you work?
A oil company.
So you work for an oil company, but you can't afford to hire a lawyer?
It's only 18 an hour, sir.
All right. Do you have dependents that you support?
No.
Do you have other court cases you have to pay off?
Just a ticket.
I think it's questionable whether you qualify for court-appointed assistance here, Mr. Alvin.
Okay.
At this time, I'm going to deny appointment of a lawyer. That can be readdressed by the court in the future if necessary. I highly suggest that if you want legal assistance, that you go out and see if you can't get a lawyer hired on the resources that you have available to you.
Okay.
I'll set your next court date for September 22, 2025, 9:00 a.m. That's by Zoom. You must be on that Zoom meeting on time that day.
Okay.
9:00, September 22, 2025.
Okay.
All right. Now, currently, Mr. Albin was brought in on an active arrest warrant. Apparently, summons wasn't effective to reach him. I'm a little surprised you're still in custody, Mr. Albin. It's only a $500 bond.
They said no bond, no bail. So I'm confused as well, Your Honor.
Now, the active arrest warrant on its face has a $500 bond. So that's what it will be.
Okay.
It's bond, you can either post the cash or get the assistance of a professional surety, a bondsman, in other words, to bond you out. Bond is set at $500.
Okay.
Cash or professional surety required. So as of right now, you're bondable on this case.
Okay.
So
Thank you.
just don't forget about that court date and time, all right?
I won't.
Okay. And again, I'm going to expect your next court date, you're going to show up with a lawyer that you've hired. Or will have made the decision you're going to represent yourself.
Okay.
Okay. Ms. Norris, anything further we need to address on Mr. Albin?
No, Your Honor. Thank you.
Okay. And if there's nothing further, the Joshua Albin matter will currently be in recess. We'll move on to another case. Joshua Cole.
Yes, Your Honor.
It's the state of Kansas versus Joshua E. Cole, case number 2024 TR 103. Amber Norris appearing for the state, Mr. Cole from the jail Zoom location. Mr. Cole, this is a lengthy set of docket notes on what is a relatively simple case, at least on its face it would appear to be. Makes me wonder why it's taken all these court appearances to get this case resolved. Then I see that you didn't appear apparently for your last scheduled court appearance before Judge Webster on June the 16th. Why is that, Mr. Cole?
Well, Your Honor, I was on my way to court and I got pulled over on my way here to come to court. I couldn't find anybody to take me, so I just, instead of not showing up, I just figured it was worth it to chance it and drive myself. And I got pulled over on the way here, and I was actually in your county holding jail when I was supposed to be in court.
Okay. So you missed court because you got pulled over and arrested by law enforcement on the way here.
Correct.
All right. I'm sure there's another story behind all of that. I'm just dealing with this case today, Mr. Cole.
Right.
Previously, Mr. Patterson was appointed to represent you. At some point, there needs to be something done to bring about a conclusion to this case. since it's been pending since early 2024. Mr. Cole, but again, you're represented by counsel. Mr. Patterson wasn't expected necessarily to address your case today. We're going to need to reset you. Let me see what your current bond status is. You're on a no bond hold currently. Since if we let you out, you might get arrested again on your way to court next time.
I'll have a ride next time, Your Honor.
Well, I think what I'm going to do is I'm going to keep you in custody and put you on an expedited docket setting. July 18 at 1:30.
Your Honor, I just got a new job.
Well, I know, but there are implications of not appearing in court when you're supposed to, Mr. Cole.
But I only had one. I only had that one incident. Other than that, I'm begging you for another chance, sir. To bond me, let me bond out today, and I promise you I'll get this taken care of.
Well, I see docket notes from December 30 that said defendant failed to appear. Defendant failed to appear again in April of 2025. No bond hold was ordered then.
But that was a mistake. That was they told me I couldn't. I didn't know I couldn't Zoom court, and they told me I could. They gave me a login and all that stuff, and then but I got back on and got that straightened out with them. The other judge took the no bond hold off and reset me another court date, and I showed up for that.
Okay. Well, again, I'm going to let the existing order stand. I've given you an expedited court date of July 18th at 1:30. Your case can be further addressed at that time.
So I can't bond out?
Nope. And Mr. Patterson's appointment continues. No bond hold remains. There's nothing further than the Joshua Cole matter. Concluded our business on that today. We'll move on to another matter on the docket. Jonathan Friend.
Yes, sir.
It's the state of Kansas versus Jonathan Tyler Friend. Case number 2022 CR 466. Defendant appears at the jail Zoom location. Amber Norris on behalf of the state. I see a warrant to show cause alleging probation violation. Defendant residing in Poplar Bluff Community Supervision Center in Poplar Bluff, Missouri. He left the facility on November 11 and never returned, as alleged by the community corrections officer. Since this was an interstate compact case, no bond was set.
And Your Honor, does the court also see that looks like community corrections filed an addendum yesterday that lists several other violations?
No, what are they?
Your Honor, obey all laws and notify ISO of any arrest or detainment within 48 hours. Do not illegally possess, use, or traffic in any controlled substance, narcotic, or other drug. Obey all reasonable demands of court and/or your ISO. Do not purchase, possess, or consume any intoxicants, including 3.2 beer, or enter any establishment whose primary business is the selling of such. Pay court costs, restitution, and attorney fees as directed, and obtain an alcohol drug evaluation and follow all the recommendations.
Very well. Further hearing will need to be set regarding all these allegations before the assigned judge, the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be August 22, 2025 at 2:30 p.m. Defendant must fully participate at that time. August 22, 2:30 p.m. Judge Satterfield's court. The court will appoint James Watts to represent the defendant, as he had appointed counsel before. he may indeed delegate the case to Mr. Favre, but initially Mr. Watts will be appointed. And there's currently a no bond hold order in effect, since the defendant apparently is an out-of-state resident. Court's going to maintain that. If you want relief on that order, you're going to need to request relief from the assigned judge, Judge Satterfield. So for now, it's a no bond hold. Mr. Watts appointed. Court date, Judge Satterfield, August 22, 2:30 p.m. Anything else we need to address regarding Mr. Friend at this time, Ms. Norris?
No, Your Honor, thank you.
I think that concludes the business in the Friend case at this time. We'll move on to another matter. Gene Murphy?
Yes.
This is State of Kansas versus Jean Esther Murphy. It's case number 2022 TR 2680. Amber Norris appearing for the state. Jean Murphy from the jail Zoom location. Initially, the court's trying to determine why a 2022 traffic case is still pending in our system.
Because he put an address on the ticket that I told him was no longer there. The mobile home park had closed down like the week before. And
I'm not sure what that would have to do with your subsequent court appearance requirements.
I never heard anything more. I've never gotten anything in the mail or anywhere.
All right. I see failures to appear all over this docket sheet.
The first one that I actually received, I called immediately upon receiving it, which has just been like a month ago or so. But I haven't received anything. Not at my office, not at the house, not at the old mobile home park.
Is this the first time that you've seen a judge on this case?
Yes.
Well, every docket entry suggests that there was a court date scheduled, but you didn't appear on any single one of these.
Okay, they stopped me for, they said there was an arrest warrant. They stopped me in Independence. And I was there at the Independence jail for 3 days. And they called someone here and they had me pay $331 and something. And they told me there was a clerk lady there typing in this thing. And they said that took care of it. And I have heard not a word since. Not a letter, not a peep, not anything.
Well, I see you posted a bond at some point with a surety, Florio bail bonding.
Is that an Independent?
I'm not sure where it was done out of.
Oh, well, so that had to have been what, the $331?
Yes, apparently so. At least your address is listed as Independence and Ron Florio is listed as Elk City.
Okay, okay. I did post that.
There are a lot of papers in this file that aren't very helpful to the court in sorting this out. A lot of bench warrant material and that kind of thing.
Oh.
Motion for judgment on bond.
See, I've never been notified about any of this. Not one scrap of paper. And I've got a secretary that takes care of my stuff that comes to the house and the office.
You have a secretary?
Yes, I do.
Okay. All I know is I couldn't do without mine.
Well, I've been an accountant for 55 years in Independence. And so, yes, I need a Loretta desperately. So, and nothing had come. If there'd have been anything that would have come, she'd have tacked it to my forehead. So, nothing came to my office. And then she checks my mail on 1021 West Myrtle too, if I'm there. So, but we haven't gotten anything.
Okay. Well, let's sort this out, Ms. Murphy.
Okay.
It appears that the charges, at least from the printout I have, that you've got a speeding charge, 75 and a 65.
Yeah, in Leo.
Operating a vehicle without a registration or with an expired tag?
No, I had my, it was in the glove box. I hadn't put it on the plate yet because I was expecting a new plate from Washington State.
All right, did you show that to the officer when he pulled you over?
Yes,
And he wrote you anyway?
he wrote me anyway, and he wrote the wrong address, in spite of me telling him.
Okay. So today, how do you plead to these charges, this speeding charge and this tag registration violation?
I had my cruise control on and I didn't pay attention to when the speed limit, so I was doing. And,
But your plea on the the expired tag charge or the,
no, I had my tab in the glove box and I had my tag from, I was waiting for my license plate to come from Cedar Woolley. And it either got stolen out of my mailbox or got lost in the mail, which I suspect that I live in a sketchy neighborhood in Independence. So I suspect that somebody probably saw them in the mailbox and snatched them out of there for some nefarious use, because I never got them.
well, Ms. Murphy, I'm aware there are nefarious snatchers all over the place.
There are, and I live one house over from where my neighborhood starts to go north real fast.
All right. Ms. Norris, is the state still desiring to prosecute the registration violation?
Your Honor, that's what the notes reflect.
All right, very well. It sounded like she's entering a no or a not guilty plea to that particular charge. I'm not going to piecemeal the case, Ms. Murphy. If you're not guilty to one, you're not guilty at this stage to all. Further court date will be necessary. I'm a little concerned that you're in jail right now, Ms. Murphy.
Well, so am I.
As far as setting another court date way out to September or October. But every bond that's been set in the case, you've essentially defaulted on by failure to appear.
I wasn't aware of any bond, except for the one that I paid for in Independence at the jailhouse at Independence to that guy that lives in Elk City. And I never heard another word after that. Not a telephone call, not a text message, not a written notice.
Okay, but Ms. Murphy, you signed a bond that had a court date on it that told you the court date and time to come back to court.
I did not get any paperwork that night.
Well, okay, I'm going to have to presuppose that when you bonded out, you had accessible to you either through your bondsman or through the jailer access to your bond, which says that you were to appear in Butler County on May 28 at 9 o'clock. That there was a docket conducted that day. You didn't appear, bond forfeiture, no bond hold.
Okay, I was not aware of this is the first I've heard about it. I have no paperwork anywhere that said that I was to appear in May.
Now, you give me the impression that you have the resources to hire a lawyer to help you with this?
Of course I do.
Okay. Well, I'm going to give you an expedited setting here. July 18, 1:30 p.m., Judge Lee's Court, July 18, 1:30 p.m.
Okay.
That's just 9 days from now.
Okay.
But I just don't have any real optimism here, Ms. Murphy, with this entire record here of failure to appear, that you're a good risk to let back out.
Well, why wouldn't I be? I'm not going anywhere. I haven't gone in.
You didn't appear in court when you're supposed to.
I didn't get any paperwork. The minute I got that paperwork, this last one, I called somebody here and talked to them immediately, within 10 minutes, when I got it in the mail. we do not set stuff aside, period.
Well, I'm not going to change the existing order. The existing order is no bond hold. I'm going to leave it in place. Next court date's 9 days away. You say you have the resources to hire your own lawyer, and you'll appear before Judge Lee 1:30 p.m. on July 18th for further proceedings in your case.
Okay.
Ms. Norris, is there anything further we need to address regarding Jean Esther Murphy at this time?
No, Your Honor, thank you.
All right. Ms. Murphy, I think for now, this concludes our business.
All right, thank you.
All right. Your case is in recess.
That's all for the jail, Your Honor.
Indeed. Thank you for your assistance today.
We will go on the record in the matter 22 CF 27, State of Wisconsin versus Dale Kitchen Master. The state appears through Assistant District Attorney Holly Rockow as special prosecutor in this case. We have Daniel Chapman, who is defense counsel in person. Ms. Rockow appears by video. We have Mr. Kitchen Master in person in custody. We're set today in this matter for a sentencing hearing after revocation. The court has reviewed the revocation order and warrant packet. Ms. Rockow, did you receive the same?
Yes, I did, Your Honor.
Any corrections or modifications to let the court be aware of?
No, I don't believe so, Your Honor.
Mr. Chapman, did you receive the document?
I did, Your Honor.
Did you review it with Mr. Kitchen Master?
Yes, Judge.
Any material or changes or alterations?
No.
Thank you. Victims' rights compliance. I think this is methamphetamine though. All right, so Ms. Rockow, argument and sentencing recommendation, please.
Thank you, Your Honor. I spoke with defense counsel earlier today, and we calculated sentence credit. I do believe that there are 150 days of jail credit by my calculation. And so, Your Honor, the state's recommendation today is for a sentence that amounts to credit for time served of 150 days. In considering the sentencing factors, the state's considered the severity of the offense, the need to protect the public, as well as the defendant's rehabilitative needs and character. I do think that this is an appropriate sentence. I think that it is in the public interest. When we consider the underlying facts here, the amount of methamphetamine in Mr. Kitchen Master's possession at the time of the incident was about 0.9 grams, just over 0.9 grams. So considering the severity of that offense, it's relatively a relatively small quantity of methamphetamine, certainly indicative of personal use. There were some charges that were dismissed and read in based on the underlying facts. I don't believe that those read-ins aggravate the offense. I still think that this is, on the scale of felonies, a pretty lower level felony in terms of severity. I've also considered Mr. Kitchen Master's criminal history and looking at his character, and it looks to me like this is actually his first felony conviction. He has a handful of misdemeanor convictions in his history, mostly in Burnett County, a couple in Minnesota, I believe, but they're all misdemeanor convictions. It's got a couple of disorderly conduct convictions, a worthless check, some misdemeanor bail jumps, possession of THC. In looking at the need to protect the public, again, in terms of this offense, I don't believe in just looking at these facts and this case before the court. I don't believe that there's a need to protect the public. I've reviewed the sentencing after revocation packet, including the basis for the revocation. And while his behavior on supervision was quite concerning and resulted in new charges, felony charges, Mr. Kitchen Master is going to have to answer for those pending charges separately and face any potential consequences should that matter resolve with convictions. And so as we sit here today, the department's recommendation of 1 year in the county jail, I don't believe will advance any sentencing objective. I don't believe that imposing an additional amount of confinement in the county jail is going to allow Mr. Kitchen Master a better opportunity to get treatment or, maintain his sobriety. I think at this point, if Mr. Kitchen Master is focused on those things and he wants to move forward with his life and be a contributing, law-abiding member of society, he'll have to look to himself and see what he wants to do on his own in terms of sobriety. No one can make sure that he's remaining sober. No one can make sure that he's following through with treatment but himself. And so certainly I don't believe that more jail time is going to do that for him. And that's the reason, in part, why I don't believe additional jail time is necessary, Your Honor. Thank you.
All right, thank you. Okay, Mr. Chapman, argument.
Judge, Miss Rockow covered a lot of the things I was going to tell you. It is his first felony. It was 0.92 grams with the baggie, so probably closer to about a half a gram. The fleeing charge that was dismissed and read in was a 40-mile-an-hour continuing to drive for about a mile, and then he pulled into his own driveway. Probably should have been better charged as a misdemeanor obstructing in a motor vehicle. And he admitted to what he did. His probation was rocky. He spent a lot of time on holds, but as the state said, how much more jail time would be an appropriate sentence for this? I think a 6 months jail sentence for a half a gram of meth is pretty consistent. And given the lack of criminal history, I think it would be appropriate. You're going to see him again in another month for a sentencing on another matter. It is resolved. And if he can show you that he can get out and follow his bond conditions for a month, month and a half, I think that would be to his benefit. I'd ask the court to impose a 6 month jail sentence and give him a chance to come back in a month and show you he can stay clean.
All right, Mr. Kitchen Master, is there anything you want to say or you want to add?
So I'm just ready to get out and be a dad again, be sober. You know, I got a plan set in place. I got a sponsor now. I got AA meetings, NA meetings. So I'm going to try it. I'm going to try the dang thing this time instead of just getting out and going back to that same old lifestyle, man. I'm getting too old.
Who's your sponsor?
Adam from the Ruth House.
That's what I was going to ask. Who's your sponsor? And I know you've been in custody, but it still counts. How many days have you been sober?
75.
Good job. I know it's in custody and I know it's going to be harder when you're out of custody. Mr. Kitchen Master, I know that you've got a will and usually you do what you want when you want, whether or not it's legal or appropriate. And so I know if you want something, you will do it. You will accomplish it. You have to want it, Mr. Kitchen Master. You have to want it really bad.
I really do.
Take control. Have you ever let anything take control of you in your life?
Drugs.
Drugs. That's what I was going to say, because I know Dale Kitchen Master. I know you don't take anything from anybody. Maybe we need to turn around how you respond instead of react to those situations. And we'll get into that probably later in a different matter. But one thing I've learned about you, Mr. Kitchen Master, is if you want something, you'll do it. And if somebody's trying to make you do something or force you to do something that you know is not right, you won't do it. You will stand up for yourself and you will take charge and take control. So I know that you're going to use this time and you're going to work very hard to be sober. I'm glad to hear you have a sponsor. I'm glad to hear that you're looking at going into AA and all of those types of meetings, going to New Beginnings perhaps, or those kinds of things. They are very good and they will help ground you so you can take control of your life. Don't let methamphetamine or THC even, take control of your life. We've had that conversation about THC before, marijuana, and we're in Wisconsin, so you can't do it, right?
Yep.
All right. I know you're very headstrong, and when you want something, you'll get it. I know that. And that's a good quality that you've taught your children. You just have to now show them how to respond in a healthier way, in a legal way, instead of reacting. All right. So tell me about what happened because I don't get updates and things. What happened after your dad passed away and you went to the funeral? Because I was
stayed
pretty
clean.
nice.
I stayed clean till about 10 days before my arrest. And then because I lost both my dads in the same year, and my garage burned down. I lost like everything that I've had for 7 years. I lost it all. So it was a rough year, and I relapsed, and then one thing led to another, and I couldn't stop until I got arrested that day. And that's what saved my life, I think, honestly.
I know. I think before you've told me that you've thanked me for keeping you in jail.
I'm glad I'm here.
So, Mr. Kitchen Master, I think if there's some things that you can work on, and it sounds like you're trying to take hold in charge and go work on those things. Maybe, I'm gonna say maybe a little mental health evaluation. You go to get
I'm
some
on
therapy.
meds now too.
You're what?
I've been on my meds now every day since I've been in jail. I haven't missed a day. So I feel a lot better, like my depression and stuff. So I just got to continue to stay on my meds when I get out instead of
What are you going
missing.
to do when you're released from custody to help you remember to take your medication every day?
Well, I've got Candy for one. So she'll help. And then, but I'm just gonna.
I forgot about Candy, the girlfriend, because I'm like, I got Candy. I'm
My
like,
first
how
thought
does
too.
Candy help?
She's my fiance.
Well, congratulations.
But I got her, so she'll help. And she's on the board with my sobriety, my plan that I have. Like, she's really on board this time.
And she's being sober now too?
She's always been sober.
She had a slip up.
Well, she had some weed charge there, but she's always been a sober, never done dope or nothing like that. So, but she's always been supportive of me, and she's part of the reason why I'm here now in jail, because she was just seeing that I was on a downward spiral and she called me in. So, I mean, I thank her for that. I'm not mad at her. I don't harbor any animosity. I'm thankful, help me. And I've learned a lot this last 75 days with going to all these NA meetings, Bible studies, et cetera, et cetera. And I've taken a lot of tools from there, put in my toolbox that I plan on using when I get out of here. So
Glad to hear it. Really glad to hear it. Don't let being out of custody change who you have become in custody. Okay.
well,
Now, I think I recall back in the day that I think there was some contemplation of 6 months as an imposed in state or something at that time, way back when. So 6 months does sound appropriate to me. And that happens to be essentially the recommendation here, because at 180 days with time served, with good time, you would get a time served anyway. So I don't think that if you put these things in action, you're not going to be a risk to the community. And you're going to do those other things that we talked about, right, Mr. Kitchen Master?
yes, ma'am.
And you promise me?
Promise you.
And you're gonna do it.
I'm gonna.
Who's gonna take charge of your life?
Me.
Okay, so 6 months of incarceration, of jail time, that would be a time served. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. And again, this is a felony. No use or possession of any illegal, or no firearm for life, no voting in any election until your civil rights are restored. This is your first felony. No firearms ever.
Yep.
Okay. And Candy can't even have them without them being in a locked.
We don't have any.
Okay, I'm glad to hear that. All right. So I think that's all we need to go over, Ms. Rockow.
I think you've covered it all, Judge.
Mr. Chapman.
Nothing else, Judge.
All right, then thank you. Good luck, Mr. Kitchen Master.
Thank you.
Thank you, Ms. Rockow.
Thank you, Judge. Have a nice day.
You too. We will go on the record in the matter 25 CF 76, 25 CM 91, State of Wisconsin versus Brandon Coles. The state appears through District Attorney Kevin Schmidt in person. Mr. Coles appears in person in custody with counsel Joel Feliski. We're set today in this matter for a plea and sentencing. Mr. Flisky, can you recite the agreement for the record?
Certainly, Your Honor. Mr. Coles has agreed to plead to count 1 of the complaint in 25 CF 76, the sole count in 25 CM 91 to be dismissed and read in, with the parties making a joint recommendation for 90 days of jail concurrent to Mr. Coles' other sentences.
To be imposed immediately?
That's my understanding, Your Honor.
All right. And Mr. Coles, that's the agreement that you've reached?
Yes.
Is he currently sitting time?
He is currently sitting on a probation hold awaiting revocation.
Okay, all right. So, Mr. Coles, well, are these the cases that got you revoked on the other matter?
For right now,
Yes.
this case I got revocated for now.
Okay, because on you're being revoked from your last case?
Yeah, I'm getting revoked from the one you sentenced me to 2 years probation and 1 year stay in post in 2023.
Oh, okay, but not on your case before that, or right after?
Yeah, not that one.
Okay, I just wanted to make sure so I had an understanding of what's going on. Okay, so you're 43 years old, 8 years of schooling, read, write, understand English, no drugs, alcohol, or any medications, and no mental illnesses or disorders, correct?
Yep.
And did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, you did.
Did your attorney go over with you the maximum possible penalty you face?
Yes.
All right. Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on this document. Did your attorney go over your rights with you thoroughly?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Did you sign this document?
Yes, I did.
And did your attorney thoroughly go over the document with you, essentially word for word?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around June 3rd, 2025, you possessed a substance? The substance was a controlled substance, methamphetamine, and you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be up to a $10,000 fine or 3.5 years of incarceration or both?
Yes.
Do you understand that there is an agreement reached by both parties, but I'm not bound to follow that?
Yes.
I could sentence you all the way to the maximum possible penalty if I thought it was warranted. Do you understand that?
Yes, I do.
Now, did you go over the criminal complaint with your attorney?
Yes.
And in the section called probable cause, did you review those facts that are alleged?
Yes, I did.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did possess methamphetamine?
Yes.
Are you pleading guilty because you are guilty?
Yes.
Mr. Flisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty to the charge?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes, he has.
Has he looked at this matter thoroughly?
Yes.
And are you satisfied with his services?
Yes, I am.
Do you have any questions for the court or for your attorney before we proceed?
No, I don't.
Then as to count 1, the sole count in 25 CF 76, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the sole count of possession of methamphetamine. The other case will be dismissed and read in for purposes of sentencing. Argument and sentencing recommendation, Mr. Schmidt.
It's a plea to the felony. We're doing jail up front rather than probation because if you look at Mr. Cole's history, he just has not been successful on probation. When I've talked with DOC, what do we do next? They don't know. So it doesn't make sense to put him on probation, especially when both these cases, one is a simple possession. Another is him behaving in strange, erratic ways consistent with using methamphetamine. So they're both essentially simple possession. Well, they're use cases. I think the 90 days jail is appropriate for use violation on supervision. I'd ask the court to do that. Thank you.
All right, Mr. Felisky.
Thank you, Your Honor. I concur with the state's sentiments regarding this being at its heart, a substance use issue. Mr. Coles has been very upfront with me of the fact that of his substance use issues. He admitted to me that he was an addict, that he has combated this issue with himself in his personal life, in his criminal history for many, many years. I would add to that, moreover, Your Honor, it's an unusual situation where someone who is my client is very upfront about the fact that they need time in custody. Most people, in my experience, do not want to spend any amount of time in jail. I think that's very understandable, but that's not the case with Mr. Coles. He's been very upfront about the fact that he wants to be held accountable, needs to be held accountable, and that he's taking responsibility here today by entering into this plea and by agreeing to be incarcerated. I think that this is an appropriate agreement. It protects the community. It acknowledges the severity of the offense. And most importantly, I think it perhaps addresses the rehabilitative needs of Mr. Coles, his need to be sober, to stay sober, and to work on his sobriety and his recovery. I think this is an appropriate agreement, and I would ask the court to follow it. Thank you.
All right, Mr. Coles, do you have a statement? You don't have to.
I just can't kick this habit. I'm sick of it, but I can't seem to kick this methamphetamine habit.
Did you hear the conversation I was having with Mr. Kitchen Master?
Yes, I did.
How did it affect you in any way?
Yes, it did.
What were you thinking or feeling?
Like the control thing. I want to be in control of my life. You know, it's like the meth and my affiliation and stuff like that. It's just, I let it control my life.
You said your meth and your affiliation?
Yeah.
What do you mean by affiliation?
Like gang ties.
I don't know where you are affiliated or what it takes to get out of that affiliation.
There's no.
You need to control your life, Mr. Coles. What else do you want to tell me?
I want to be sober. You know, I was doing good. I went to treatment, and I don't know, on April 16th came around, I got sentenced and fell off right away.
You got sentenced when you were, or you fell off when you were sentenced on your last case?
Yep.
Why? What happened?
I don't know.
Because you were put on probation, right, with a withheld?
Right. I came to the county jail to do my DNA. They were busy. And then I told this individual, I'm like, I want to get high.
You recall what you were thinking at that exact moment?
Apparently I wasn't.
Do you know if you had a trigger?
Well, we stopped at a smoke shop, you know, like THC was bought and stuff like that. But it's like my surroundings I surround myself with, you know, like the same females over and over.
Females only get you in trouble. True. Not all, but most.
And, you know, I beat myself. I read my revocation packet, and from the treatment, they have nothing but good things to say about me, you know. And I know I'm that person, but I can't kick this method.
You have to find that person again. And as I told Mr. Kitchen Master, only you can control your life. Only you can control what you do. Because right now you're letting methamphetamine control you. And you've got to be strong. You've got to be a tough individual. You have to be somewhat like Mr. Kitchen Master. I don't know you as much as I know Mr. Kitchen Master, but you have to, knowing what I know about you, you have to be strong-willed and take charge of things.
My mental health ain't like, it's like destroyed.
What do you mean?
You know, I hear shit, see shit.
You're not supposed to swear in court.
I see things, you know, think I'm being followed, chased.
Have you had like a medical evaluation?
Not yet.
Or a mental health evaluation?
Not yet.
You could need to be on medication. And did you hear Mr. Kitchen Master? He's been taking his medication every day as he's prescribed to take, and he's feeling amazing, like a real person. Because I'm gonna bet that in your situation, when you have the addiction and you're doing the bad things, you don't feel like a person, do you?
No. Nobody wants to be around me, period. You know, because of my paranoia or whatever it is, you know, like.
Do you know there's meth psychosis? There's THC psychosis. There's things that they affect people's brains. And now with the THC levels, and this is speaking to Mr. Kitchmaster too, the THC levels that we have now, because they're chemically engineered and bioengineered, are so much higher than they were in the 1950s, 60s, 70s. It's like it was, I believe, like, don't quote me, I don't know exactly for sure. I haven't read it in a long time, but THC levels in like the 1960s, 70s was like 5%. It's like 35 or more percent now in the marijuana that is being produced. Do you know what that does to a person's brain? Destroys it. It makes them have a psychosis where they don't know where they are, where they're doing the things that you were doing in the other case. When you're here like this, and you've been sober for a while, you are sober, how do you feel?
I feel good. You know, like, you know, I'd seen Pastor Jack and he's like, I heard you're a really good dude when you're sober. I mean, I believe that. I really am. You know, like when I'm not under the influence, I'm a really good person. I can light up a room. I feel good about myself.
That. I feel you have a good personality, but you're letting the substances control you in your life. And then the affiliation. Okay, again, I can't get into that. I don't know about that. Well, you've been sober. Have you been hearing the voices?
Yeah.
You still hear them? So then that tells me, go ahead.
I try to ignore it, you know, like overpower it, because I believe like if you entertain spirits, bad spirits, they're going to keep coming. But I mean, I hear them and then, you know, or I think people are doing shady things or whispering, talking and stuff like that.
Are you Native American? And
Yeah,
I'm not
well,
asking to be.
I'm Samoan, Native and white.
Okay, so do you connect to any part of your heritage?
Yeah, I follow Native American.
And have you went back to that and to their customs, to their traditions, and have you engulfed yourself in the Native American customs?
I mean, I have in prison, you know, I haven't been out long enough to, you know, even get to it, you know.
Have you reached out to anyone here in the St. Croix tribe?
Not like that.
That would be a good idea. Get involved in the powwows, get involved in the drumming, get involved in those spiritual ceremonies. When you are giving yourself to that higher power and you are engulfing yourself in your customs and your heritage, you will be brought back. And you can find you. Because I don't know if Mr. Coles knows who he is right now. I don't think you've known who you were for a very long time. Correct?
Correct. You know, it took 22 years for my son to come back around. I just got him back, you know, in my life, and here I am. And I made a promise to my daughter that I'd be off for her birthday, which was on Father's Day, and she's a little upset. She won't talk to me now, and so I understand.
I'm sorry for the councils to know, because I am looking at 24 CF 222, State of Wisconsin versus Brandon Coles, where Angeline Winton, Judge Winton sentenced him, because I wanted to see the conditions that she sentenced him to. Does anyone object to that?
No, I don't object.
Because I was looking to see if there was a mental health assessment or a medical assessment to determine if you need to take drugs every day, because right now you're self-medicating to get the voices out of your head, but what it's doing is bringing the voices out even louder and stronger. Correct?
Correct. I mean, I'm trying to fight for ATR to go down to Janesville with that dual treatment for mental health and substance abuse.
That would be great. That would be excellent. If you don't go there right away, can you make me a promise?
Yes, I can.
Can you go to the tribe and see what you can get involved with?
I will.
Can you talk to the tribe about a mental health evaluation?
Yes, I will.
And maybe, I think they have a physician there. You can go and get a medical evaluation to see if you need some types of prescriptions to get you on track.
Yes, I will.
Can you do that for sure?
Yes, I will.
Okay. So, Mr. Coles, I think that this agreement is appropriate. You're still going to be on probation for that other matter. And you're being revoked from my previous one in 2022 or 2023. I bet you thought I was real mean then, huh?
No, actually, I didn't, because you went against the plea agreement then.
Oh, I don't even remember what the plea agreement was, but I know I sentenced you to 1 year.
It was supposed to be 2 years withheld, and you went against it.
So, Mr. Coles, what I'm going to say to you is when you're sitting the time, if you're revoked, if you are revoked, I think you said you had a hearing. If you're sitting that time, take that time to find you. And I told Mr. Kitchenmaster, you were here, you sat and you heard that even though it's in custody sobriety, it still means a lot. It's still a lot. Okay? It just means it's going to be harder when you're out.
I was sober for 7 months.
That's amazing.
Yeah, I never thought that's the longest I've ever been sober my whole life.
That really is amazing.
Even though some of it was jail, but still, it's still sobriety.
Get back to that. Okay, get back to that. Get back and find who Brandon Coles is. You've lost him along the way. Okay, and I didn't mean to make this so long. I just wanted to say a few things to you. So the 90 days is appropriate to run concurrently. This is such a little case. It's just a possession case. I'm more concerned about the behavior in the disorderly case, the underlying behavior there, than I am in the use case, because the use will be addressed in your other probation and other case. That's why I'm talking to you and hoping that you're gonna abide by your promises to me, and you're gonna go get those evaluations. Because if you get those evaluations, then my concern about the disorderly case will significantly lessen. Okay?
That's what led up to that disorderly case. Was I thought I was being chased.
I can figure that from the facts. I do. I see that. You weren't who you truly are meant to be at that date and time. You were letting something else take over you. All right. So you have 60 days to appeal, or 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. It is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. I'm just going to give you a little bit of break on the fines and fees. I think you owe in other things too. So I'm only going to do the DNA surcharge of $250. I'd like to see you try and work and pay that off. I'd like to see that. When you're released from custody, you can pay it off at $25 a month until it's paid off in full. I would pay it off sooner. You know, this judge does warrants if you don't pay your fines and fees.
Yeah, you make me nervous.
I make you nervous?
That's what I told Joel before the meeting. I said, she makes me nervous.
Why do I make you nervous?
I don't know. I don't know.
You think I'll go AWOL and I'll do what I want?
I mean, you can.
I can. It's all in my authority. Mr. Coles, what I look for and what I look at in sentencings and in cases, I look at the person. If you don't recognize, I know Dale probably inside and out. So, has he done bad things? Sure has. Has he had his time with me? He sure has, but we have worked that out. Okay? Because it's all about the person and the case and the facts and knowing that. That's what sentencing is, at least in my book. So, all right. So keep your promises. Pay your fines and fees when you're released. 20 days to appeal. The other case is dismissed and read in. You have 38 days of jail credit, I believe. Is that stipulated?
Yes.
Anything else?
Nothing further. Thank you.
Have I missed anything else?
Not for me.
All right, then we're adjourned.
Thanks, Your Honor.
Thank you, Mr. Coles. Please keep your promises.
Well. How about that for a week full of court cases, ladies and gentlemen? Started off strong on Monday. We maintained the velocity all the way through Thursday. I'm not even going to bother talking about Friday. We all just watched a 2-hour crazy Middleton feature session from Friday. It's still up and live, ladies and gentlemen. If you want to see it, you'll probably see a link to it right as this live stream goes down. Keep in mind that I am running a little live chat, watching a premiere every single weeknight. We do that around 9 p.m. Eastern time. And then I do this little thing every single Saturday at noon Eastern, where we watch the court cases of the week, see what we can see, and talk about what we want to talk about. Sometimes we've seen the stuff before and we just want to comment on it. Sometimes we haven't. I think we had a lot of unique cases today. I was very interested in seeing all of them. I hope you felt the same. I am your Lone Wolf Usul. I am your host for this here court gallery, the curator for this here channel. I appreciate you coming by and hanging out with me. Hope I'll see you next time. For now, I'm just going to say, Hermiticus, thank you for coming out. Cat and Virginia, thank you very much for that donation. Triple J's, really thank you a lot for that donation earlier. I didn't say anything when it happened. I don't pause the videos to actually say that when that happens, but hey, I can save it to the end. I've thought about doing the whole little give a super chat question and I'll answer it at the end of the live stream, but yeah, I'm not that much of a specialist. You don't want to hear me wax philosophical about this stuff. I just don't know any more about than you do, but I'm always happy to hang out with you and check out the videos with you. Happy to find the stuff for you and collate it into a much more digestible form. For now, we'll say thank you very much for your patronage. Thank you very much for enjoying these videos with me, because I enjoy this as much as you do. I am a content consumer as much as I am a content creator. I hope you come by and hang out with me next time. And for now, I'm your Lone Wolf Usul, and I'm out. See you later. Bye.